United States v. Knotts, Supreme Court, 1983. Justice Rehnquist announced the opinion of the court. A beeper is a radio transmitter, usually battery-operated, which emits periodic signals that can be picked up by a radio receiver. In this case, a beeper was placed in a 5-gallon drum containing chloroform purchased by one of respondents' co-defendants. By monitoring the progress of a car carrying the chloroform, Minnesota law enforcement agents were able to trace the can of chloroform from its place of purchase in Minneapolis, Minnesota, to respondents' secluded cabin near Shell Lake, Wisconsin. The issue presented by the case is whether such use of a beeper violated respondents' rights secured by the Fourth Amendment to the United States Constitution. Respondent and 2 co-defendants were charged in the United States District Court for the District of Minnesota with conspiracy to manufacture controlled substances, including but not limited to methamphetamine, in violation of 21 U.S.C. Section 846. One of the co-defendants, Darrell Petchin, was tried jointly with respondent. The other co-defendant, Tristan Armstrong, pled guilty and testified for the government at trial. Suspicion attached to this trio when the 3M Company, which manufactures chemicals in St. Paul, notified a narcotics investigator for the Minnesota Bureau of Criminal Apprehension that Armstrong, a former 3M employee, had been stealing chemicals which could be used in manufacturing illicit drugs. Visual surveillance of Armstrong revealed that after leaving the employ of 3M Company, he had been purchasing similar chemicals from the Hawkins Chemical Company in Minneapolis. The Minnesota narcotics officers observed that after Armstrong had made a purchase, he would deliver the chemicals to co-defendant Petchin. With the consent of the Hawkins Chemical Company, officers installed a beeper inside a 5-gallon container of chloroform, one of the so-called precursor chemicals used to manufacture illicit drugs. Hawkins agreed that when Armstrong next purchased chloroform, the chloroform would be placed in this particular container. When Armstrong made the purchase, officers followed the car in which the chloroform had been placed, maintaining contact by using both visual surveillance and a monitor which received the signals sent from the beeper. Armstrong proceeded to Petchin's house, where the container was transferred to Petchin's automobile. Officers then followed that vehicle eastward toward the state line, across the St. Croix River, and into Wisconsin. During the latter part of this journey, Petchin began making evasive maneuvers, and the pursuing agents ended their visual surveillance. At about the same time, officers lost the signal from the beeper, but with the assistance of a monitoring device located in a helicopter, the approximate location of the signal was picked up again about 1 hour later. The signal now was stationary, and the location identified was a cabin occupied by a respondent near Shell Lake, Wisconsin. The record before us does not reveal that the beeper was used after the location in the area of the cabin had been initially determined. Relying on the location of the chloroform derived through the use of the beeper and additional information obtained during 3 days of intermittent visual surveillance of respondent's cabin, officers secured a search warrant. During execution of the warrant, officers discovered a fully operable clandestine drug lab in the cabin. In the lab area, officers found formulas for amphetamine and methamphetamine, over $10,000 worth of lab equipment, and chemicals in quantities sufficient to produce 14 pounds of pure amphetamine. Under a barrel outside the cabin, officers located the 5-gallon container of chloroform. After his motion to suppress evidence based on the warrantless monitoring of the beeper was denied, respondent was convicted for conspiring to manufacture controlled substances in violation of 21 U.S.C. Section 846. He was sentenced to 5 years imprisonment. 2. The governmental surveillance conducted by means of the beeper in this case amounted principally to the following of an automobile on public streets and highways. We have commented more than once on the diminished expectation of privacy in an automobile. One has a lesser expectation of privacy in a motor vehicle because its function is transportation and it seldom serves as one's residence or as the repository of personal effects. A car has little capacity for escaping public scrutiny. It travels public thoroughfares where both its occupants and its contents are in plain view. A person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movements from one place to another. When Pechin traveled over the public streets, he voluntarily conveyed to anyone who wanted to look the fact that he was traveling over particular roads in a particular direction, the fact of whatever stops he made, and the fact of his final destination when he exited from public roads onto private property. Respondent Knotts, as the owner of the cabin and surrounding premises to which Pechin drove, undoubtedly had the traditional expectation of privacy within a dwelling place insofar as the cabin was concerned. But no such expectation of privacy extended to the visual observation of Pechin's automobile arriving on his premises after leaving a public highway, nor to movements of objects such as the drum of chloroform outside the cabin in the open fields. Visual surveillance from public places along Pechin's route or adjoining Knott's premises would have sufficed to reveal all of these facts to the police. The fact that the officers in this case relied not only on visual surveillance, but on the use of the beeper to signal the presence of Pechin's automobile to the police receiver, does not alter the situation. Nothing in the Fourth Amendment prohibits the police from augmenting the sensory facilities bestowed upon them at birth with such enhancement as science and technology afforded them in this case. We thus return to the question posed at the beginning of our inquiry. Did monitoring the beeper signals complained of by respondent invade any legitimate expectation of privacy on his part? For the reasons previously stated, we hold they did not. Since they did not, there was neither a search nor a seizure within the contemplation of the Fourth Amendment.